Welcome back to the Environmental Law Monitor. I'm Daniel Pope.
And I'm Taylor Stuart.
This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Practice Group. And this podcast is a place for thoughtful conversations as we cover the latest developments in environmental law and policy, in addition to perennial topics like litigation, enforcement, and compliance assurance. We're glad you're spending some time with us today. So when it comes to new agency rules, whether we're talking about rules from EPA or from the Fish and Wildlife Service or from the Securities and Exchange Commission, any federal agency, really. One of the most common topics of conversation during a presidential election year is the Congressional Review Act, or CRA. It was enacted in 1996 and for a while was sort of a sleepy act. It allows Congress, though, to overturn rules, assuming a rule's opponent can muster enough support to render the rules ineffective.
And technically, Congress can do this at any time, right? So when a federal agency finalizes a rule, it sends a copy of the rule to Congress for congressional review. Congress has a window to review the rule, and then it can pass a joint resolution of disapproval. If that resolution is then signed by the president, or if there are enough votes to override the presidential veto, then the rule is rendered ineffective.
The CRA is always around, but I think practically speaking, one of the reasons that we talk about this during big election years is that the prospect of using the CRA to overturn major rules is probably minimal, right? For most of a president's term. The president is not going to sign a joint resolution of disapproval, even during a divided government, that overturns like some of his signature administrative policies and achievements, right? So he's not going to nullify the work of the agencies he oversees.
Yeah, that's exactly right, Daniel. But because of the way that the CRA works, it takes on a special relevance in an election year. And to help us understand the dynamics around the CRA, we had our friends at the Policy Resolution Group, Joe Brazauskas and Liam Donovan, join us for a conversation about how the CRA works, what could happen in November of 2024, and of course, the implications of the upcoming election for environmental policy. So we hope you enjoy the conversation.
So thanks for being with us, Joe, Liam. If you're like me, you are just getting blown up every day in your emails and other notifications as all manner of rules go final. We're recording this in the middle of April, and we are looking at just so many policies of this administration being finalized. And that's chiefly in the form of rules, but we're also expecting to see guidance. And one of the things that comes up in all of these news alerts around this time is the Congressional Review Act. So thanks for being here. Thanks for helping us understand what the real dynamics are around the Congressional Review Act and how it works and what the implications are for this administration's policies. Thank you both for being with us.
Good to be here.
Thanks a lot, Daniel.
Joe, I have benefited so many conversations with you from just your deep understanding of the CRA and especially the lookback period. And when I think about the lookback period, I think of myself as sort of a novice in this area. You're the expert, you're the sage. I had that sort of Zach Galifianakis gif where he's like trying to do the math and all of the equations are in front of him. The look back period, the look back window is just really interesting. So tell us about a little bit about the CRA, but also about how the look back period works and why that's relevant for all these rules we're talking about right now.
Sure. So of course, the Congressional Review Act gives Congress the authority to disapprove of a regulation that has been promulgated by the executive branch. And as part of that law, Congress is required to have 60 days to review any of those rules. So particularly when you're headed into a presidential election year, the number of days that Congress is actually in session, which is part of that 60-day review period, tends to be truncated as towards the end of the year. So of course, you have the entire House, which is up for re-election. You have a portion of the Senate that is up for re-election. So there are just not as many in-session days in the sort of latter half of the calendar year. And so what this means is that federal agencies are hastening their finalization of rules to try to prevent the ability for Congress to then be able to look back at any of those rules that are made in the future Congress. essentially, if Congress doesn't have that 60-day period to review the rule, then the next Congress gets 60 days starting on January 15th of the next Congress. So what we are seeing is as I've said, federal agencies are rushing to get rules completed, to have them published in the Federal Register and reported to Congress. So even if, say, the election, and I think that's where the presidential election really comes into play, as well as the individual House and Senate elections, because we've got a Democratic administration currently, and Republicans were to establish a unified government with the president, the House, and the Senate, then any of those rules that fall within that look-back period would be able to be reviewed by the Congress next year. And any sort of disapproval that passes both a Republican House and Senate, that disapproval would be signed into law by a theoretical Republican president, thereby disapproving the rules of the previous Biden administration.
It's probably obvious, but just it's out there. The Congressional Review Act applies at all time, right? And we have this sort of heightened, intense conversation every 4 years where there is a significant number of the senators that are up for re-election, the entire House, and obviously the president, right? It's kind of this big shakeup. But the CRA, you can file a joint resolution of disapproval at any time. It's just that the executive, the president, is not going to sign a resolution of disapproval should it pass and make its way to the resolute desk against one of his own agency's rules, right?
Well, Daniel, to your point, we've been doing that throughout the Congress. We've been doing it last Congress. It's the reason why this is such a powerful tool is because it's one of the few items that a Senate majority or a coalition that makes up a majority of the Senate can do around the filibuster. So we talk about reconciliation a lot as a way to get around the filibuster, but the CRA is the other tool that you have. So let's say you have 49 Republicans that want to do something and they can get Joe Manchin and John Tester or somebody like that to do it, and they have the House majority. You can get that to the president, and as a messaging device, as a political matter, you can force him to veto it. And of course, you can't overcome that veto, but as a messaging political exercise, it works. It has its own utility. But to your point, it's always something that's out there, but it's kind of going through the motions unless and until we have a change in administrations.
Yeah, that's exactly right, Liam. We've seen this Congress, a number of CRA motions brought both in the House and in the Senate, and a number of them have hit President Biden's desk and he's vetoed them. So, and there's at least 3 that I can think of that are kind of swirling right now with regards to there's talk of a CRA for the SEC climate disclosure rule. There's talk of a CRA on the EPA's PM 2.5 regulations. There's a recent heavy duty truck rule that is a possibility, the EPA tailpipe emissions. So these are all rules that are not within the look back period, but certainly Congress is considering taking action on the CRA, as Liam says, as a messaging device to put the pressure on President Biden, demonstrate that Congress disapproves of this rule, and make him take that effective step to veto those disapprovals.
Are we able to talk back from the timing of the November 2024 election and think through what is a safe period by which an agency should be proposing or finalizing to try to stay out of the look back period? I feel like I've tried to do that math. I hear people talk about April and June being significant dates for many reasons, but I'm just thinking, like, is there a date by which we kind of know, all right, at that point, you're probably looking at being within the look back period and your rule is under threat?
Yeah, thanks, Taylor. So we don't know exactly when that sort of 60-day look back period will start, but can generally say that sometime maybe around late May, definitely as we get into June. I think that's sort of more of the vulnerable period. And keep in mind that one of the requirements of the CRA, of course, is that the rule, in order to start the clock, that the rule has to be printed in the Federal Register and reported to Congress. So as a number of rules start to come out around this deadline period, there may be backlogs, for example, at the Federal Register. It takes time to get these rules printed. There may be issues with reporting the rule to Congress. So it's hard to say. Certainly agencies finalize rules. They publish them on their webpage, but the clock does not officially start until those effective steps are taken. And one thing I think is just important to note is We saw some EPA methane regulations come out earlier this year. They were released by the agency and they took many, many weeks. It was a 1,000-page document for them to actually be published in the Federal Register.
Just to put a finer point on it, to Joe's point, there is uncertainty around the front end is in terms of when these things are formally promulgated, but also the back end insofar as we don't know which days Congress will add back or take away. If you look at the majority leader's website in the House, and that's the lowest common denominator here, because of course, Democrats could add back in the Senate. Schumer could add back days in the lame duck session to give extra days, but the House would not. If Democrats had a majority in the House, they could do the same thing. But Republicans are very aware of this look back matter. They're not going to do any favors in that regard. And so if you look at Steve Scalise's calendar as it exists right now, if you just count back 60 days, and again, there's reasons to think that'll change, but if you just count back from the last day they are scheduled to be here in December 19th, and I rather doubt they'll necessarily be here on December 19th, but if you start from there and work back, the 60th day is May 17th. And so that's why late May becomes your sort of threshold. Of course, that's there's some fluidity there, but that's why we are getting into pressure cooker territory. And to Joe's point, there really is kind of a bottleneck as in terms of all these agencies trying to do the same thing and get it to the register at the same time. It's going to be tough and things will spill into that window where there's exposure.
And I think it's just really important to note because we're talking a little bit about, is the CRA just a messaging tool? Does it actually have the teeth that we think it was intended to have in terms of actually disapproving these rules? Well, I think one thing to note is that regardless of whether or not a rule is actually disapproved in a future Congress with a future Republican majority, I think what we are seeing is that the Biden administration and other administrations in a theoretical final year take the CRA very seriously. They want to ensure that their rules are completed before that look back period exists. So does that mean that they are willing to finish a rule potentially before it's actually completed? Does that mean that there may be certain vulnerabilities within a rule that may exist for litigation down the line? It's certainly possible. We've seen, of course, that there may be some EPA rules that related to power plants, which have been split in parts because they know they can get one theoretically done before the window, but the other one they can't. So there is a real impact of this look back window that the agencies and that the administration do take very seriously.
To Joe's point, this was a tool that for about 20 years was really just seen as was passed in 96. It wasn't something that was seen as particularly, the teeth Joe talks about were sort of latent until the Trump administration came in. And that's the function of two things. Number one, it was seldom used before that. I think there was an OSHA ergonomics rule that the Bush administration overturned, but it wasn't, obviously that's not terribly sexy. It's not something that people think about or remember. And so it just sort of sat out there until you had a confluence of two things. Number one, a trifecta, a surprise trifecta in the form of the Republicans coming in January of 2017 and an Obama administration that was fully expecting to have 4 more years in power and weren't as methodical about taking care of the back door and making sure that everything was squared away before that window. So I think that's a lesson learned, and all of the scrambling and all of the sort of deliberation that Joe's talking about is a function and a lesson of 2017, where it went from this is something that was used one time in 20 years to something that was used 14 times in the first 100 days, 16 times in the administration. And so this is a Republican Party that is more apt to use its power in ways that previously weren't thought of that way. I think the Biden administration appreciates that and will prepare for it accordingly.
I think that's a great point you made earlier too, Joe, about the tension between the CRA and the requirements of the Administrative Procedure Act. If you rush a rule, especially a big rule, and those are the kinds of rules that take a long time for agencies under the first term of an administration to prepare, to document, to respond to comments, to do regulatory impact analyses, and so on and so forth, right? There's a lot beyond just what's printed in the Federal Register that's still relevant for administrative litigation. If you don't have all of those ducks in a row, obviously that takes longer, and then you're coming closer to to that look back period beginning. And so I think that's really interesting. And one of the things I'll note is that just recently, Administrator Regan talked about how the CRA is secondary. His focus is on making sure that rules are defensible. And I think he was talking about some lessons learned after the Supreme Court's decision in Sackett versus EPA when he was making those remarks. And so we'll see how that works out as we get towards that period, because there are so many important initiatives coming out of EPA, so many controversial initiatives coming out of EPA that I think the CRA, especially in view of what we're looking at in November, is really a relevant concern. So I'd love for us to talk a little bit about that. We've glossed over or spoken briefly just about how the CRA takes on special relevance in an election year, especially a presidential election year. Joe, I take your point that messaging is still significant as an important part of what any particular politician can take back to their constituents and say, I'm on record as opposing X, Y, or Z. But it seems like we're shooting with live ammunition here when we get to an election year where we have so much up for that. So tell us about how that works and what developments are we seeing leading up to this November that are important for understanding what the CRA might look like this go round.
Daniel, you're right. There are a lot of initiatives that the Biden administration wants to complete before the election and outside of this CRA window. Of course, we have all those environmental initiatives, which we've spoken about at EPA. There are also a host of IRA provisions and IRA rules coming out of the Treasury, which have just the Treasury and has been working to try to finalize a number of rules which are related to the energy transition. And just because there are so many rules, I think we've seen the deadlines pushed out further and further. And certainly a lot of those provisions may in fact be vulnerable to the CRA. And so there is obviously, if the Biden administration wants to make sure that it gets its priorities finished and on the books before there may be a new administration in Washington, D.C. I think it's also really important to note that one of the provisions of the CRA is that if a rule is disapproved, then the federal agency cannot promulgate a substantially similar rule in the future. And this is an issue which is particularly interesting because it's one that the courts really do not want to deal with. They've sort of said, well, it's really up to Congress. And so there's sort of this notion that, and it creates an issue, of course, where Congress may have passed a piece of legislation which instructs a federal agency to promulgate a regulation. And then Congress can disapprove that regulation. And then the federal agency is now in a situation where they say, well, Congress told us we need to write this rule. So how are we supposed to write it? And it's this sort of tension between, does the federal agency go back and try to rewrite that rule? And then is it up to Congress to then CRA that rule again if they feel that it is substantially similar? I think that's sort of how many people look at this. And then also that we have some very significant cases before the Supreme Court related to agency discretion in the Loper case, which will be decided in June. And that very well may also impact any rules that would theoretically be disapproved where there is a need to promulgate a substantially similar rule. There are a lot of interesting issues here. I think they are very real. And we will certainly see what rules make it into that window and become vulnerable to a potential future administrative action.
I think Joe used a phrase that's important to take note of because it's a reminder, not only does this take on specific importance at a time of potential presidential transition in the sense that, of course, the entire regulatory regime hangs in the balance anytime you're talking about a presidential election. But specifically when it comes to CRA, you have to keep in mind the asymmetry at work. When you have one party that likes regulation, one party that doesn't particularly like regulation, it's a deregulatory mindset. And so that phrase that Joe used, substantially similar, is the key here because Republicans are happy to use this tool that will nuke these regs and prevent anything from going there in the future, whereas Democrats are going to be fundamentally and temperamentally less inclined to use this tool if the shoe were ever on the other foot because they actually want to regulate. It's not I think that question of, okay, well, what happens in the wake of a CRA, what happens in the wake of disapproval is something that looms large in this and is a reason why it is much more of a threat if you have a potential Republican trifecta versus if you were ever looking at going the other way. It's not like, put it this way, when Biden came in with a trifecta, they didn't use the CRA. Think about that. They didn't use the CRA at all. Even though they hated all of the Trump administration stuff, all they did was use executive action, use APA, use their tools at their disposal. So I think that's the thing I would note is it's not every time the presidency switches. It is specifically if you go from a Democratic administration to a Republican trifecta.
That makes sense, Liam. And something that Joe said, about the judicial review issue just has me thinking that the CRA does seem to be such a strong tool because of that substantially similar requirement, right? If the Biden administration comes in and knocks out a Trump administration rule using their executive authority, that's something that a future conservative administration could still come back and maybe try to rewrite that or do something that's similar to that. But if you knock it out with the CRA, it does seem like you're back to the drawing board, and then there is no kind of court intervention that can say this is unreasonable for the agency to do. It's really up to the agency, right, to determine whether something's substantially similar. And then if Congress finds that it isn't, it can go back around to another joint resolution of disapproval and do it all over again. I mean, it is a really interesting process, but it does seem to me to be a powerful tool to avoid something like the OSHA ergonomics rule coming back around again. If there's something that a certain unified Congress is thinking, we don't want to see this ever again, the CRA strikes me as a very strong way to avoid having to see those regulations proposed again in the future.
It's such a litigation attracting phrase, right? Substantially similar is kind of up there with like reasonable person.
That's right.
And I'm just really interested to see what that litigation eventually looks like. You could imagine with the NEPA phase 2 regulations finalized at some point, maybe it happens this month, maybe it happens in a couple months, but imagine a Republican administration striking down those phase 2 regulations. Well, with those regulations emphasis on the analysis of climate issues, environmental justice issues, could a subsequent administration take those back up, prepare a sort of different architecture for considering those kinds of impacts that's different from what the CEQ is currently proposing and say, okay, well, this is not substantially similar, even though it's in the same sort of area of concern. That's certainly going to be litigated at some point. Whether that is justiciable or not, I think is for a court down the road to decide.
It invites litigation, right? But Joe, is there the ability to litigate over it? Because I think I've heard you say in the past that there really isn't a lot of litigation because there's not the opportunity for judicial review under the CRA. Is that right?
Yeah, that's correct. And I mean, there has been attempts at litigating this issue, and courts have they do not want to take this up. They want to avoid sort of, I think, what they would view as almost somewhat of a constitutional crisis, and that, right, and that's very specific with regards to instances where Congress says promulgate this rule and then disapproves the rule that they said that they wanted promulgated. And so it's one of these issues where I think you have to take like a very basic view of what the CRA says and sort of how sort of courts view that, which is that, and they sort of remove all the politics. They say, well, if Congress wrote the CRA and if they disapprove this rule and an agency promulgates a rule, again, that under the substantially similar scenario, then it's up to the Congress to disapprove that rule again, which sounds somewhat humorous because we know how Congress works. They don't always act in the way that maybe courts think they ought to act, but that's sort of the general thinking under this statute. So, and it is where then the politics start to come into this, is that if Republicans disapprove a rule that they don't like, but then the Republican control federal agency promulgates a rule that they do like, which some people may think is substantially similar, well, they're not going to CRA that. They'll let it sort of move forward. And then once that's outside of the review window, then it would be up to a future Democrat administration to sort of utilize the APA process to withdraw the rule and promulgate a new one. So that's kind of, I think, the scenario that we would be dealing with.
Liam, as we approach November, what are we looking at? What's really in play, and what outcomes would either preserve some of the rules that we're talking about here, right? Because a CRA is not a fait accompli, right? They actually have to get the resolutions passed and signed. So what outcomes would put this administration's policies at risk? What outcomes would protect this administration policies? Maybe if President Biden isn't reelected, what are the sort of contingencies there?
Yeah. So if you're thinking about your potential scenarios and what the mode outcome might be, let's say, versus sort of the things that are lower likelihood, I think perhaps the lowest likelihood is a Democratic trifecta. And that is purely a function of the Senate map. The Republicans have 49 seats right now. With the retirement of Joe Biden, that's almost a certain pickup there in West Virginia, which goes to 50, right? So because Democrats don't have much to shoot at, they could say, yeah, we have a chance in Florida or Texas on a night where Trump does anything but completely implode. Those are going to be safe seats for Republicans. So that means 50 Republican Senate seats. That plus Trump gives a majority. But that doesn't stop there, because you have two more seats, Ohio and Montana, which on any normal night is going to go to Republicans. Montana probably a 19, 20 point Trump victory. So it's very likely that you have probably a 90% chance, I'd say at this point. I mean, I struggle to put numbers on it, but to get your head right, you should probably bake in, barring something unforeseen, a Republican Senate. So without a Republican trifecta, these rules are safe from the CRA. But of course, if Trump wins and maybe you have a divided government where Trump wins, Republican Senate and a Democratic House, I'd say that's probably, people are a little too bullish on the scenario, but it's not out of the question. Let's say it's a 50-50 presidential. In those scenarios, maybe 20% of the time or something, if Trump wins, you might have a Democratic House. That would be enough to probably save you from a CRA situation. But of course, with Trump in power, he'd be able to revisit some of these regs, but have to go through APA process. He would take the administration's just direct executive actions, roll them back, or put in place his own policies. It is probably at this point, if you believe the polls and Trump's winning everywhere, he's leading in all the battlegrounds, that is suggestive of a Republican trifecta. That is the scenario we're talking about. That is where the CRA is live. And to your point about you can't take anything for granted, that's absolutely true. The CRAs, you'll have to sort of see what their subject matters are. But if you're thinking about what a theoretical Trump administration could do with Republican majorities, as a legislative matter, I think we've seen previously and we're seeing even today, Republicans can't agree on much. They can often agree on what to take away, what to strike down. So I do think the CRA becomes the most attractive tool in their toolkit, that plus reconciliation. And there's a lot of reasons why that's going to be important in a 2025 scenario with Republican trifecta, or even without one, given the range of fiscal issues at play. But if you're thinking about the likely scenarios, I think there's probably maybe a 10% chance that Democrats have full control. Biden had a really good night and they somehow protect the Senate. But the more likely scenarios are either Republican full control, that's probably a third, maybe 40% of the time, and the balance is some form of a divided government where Biden wins, probably has a Republican Senate and a Democratic House.
Hey, Liam, I want to just ask you a question here, because we are seeing a lot of reporting about the dysfunction of the House, about how their actions by Republicans are just putting themselves in the situation where they will be in the minority next Congress. But I think what you are saying is that if Donald Trump has a good night, the chances that the Democrats take control of the House is very low. Is that right?
That's correct, Joe. I mean, it's not to say that it can't happen, but I think you need to keep in mind these things aren't happening on different planets. And this is one of the errors that people made in trying to handicap in 2020. People tried to compartmentalize what was happening in the presidency versus what was going to happen in the House. People predicted, well, it's going to be a really close presidential race, but also Democrats are going to pick up 50 seats in the House. That's not how it works. And so if we believe the polls and we believe that Trump is either favored or a 50-50 proposition, you shouldn't be measuring the drapes for a Hakeem Jeffries speakership. That's not how it works. While the edge cases would be, okay, Trump has a good enough night to win, but Democrats do so well in New York and California that they can somehow cobble together 218 seats. But the reality is Trump is going to do pretty well on Long Island on a night where he wins nationally. And even in 2022, if you're thinking about where the red wave did materialize, it was places like that. So I don't think you can divorce what happens in the presidency from the House. It's a non-zero chance, and it would be very strange to see that happen historically. It's more likely than we would otherwise think of it, but it's certainly in that sort of low likelihood scenario, kind of along the lines of a Democratic trifecta.
Liam, you were talking earlier about how the CRA may be an attractive tool for Republican trifecta to go after some of this current administration's policies that are in that look back window. And for both of you, really, I have a question about how much margin do you think is necessary? Because we've seen over the past few years, as both chambers of Congress are so narrow, like we have such narrow majorities, that the movement of one or a handful of people can really change what that chamber is able to do. So in 2024, if, say, the House turns red again, will there need to be a sufficient margin for something like the CRA? Or is that such an easy thing to pull off that it won't be difficult to whip up the right number of votes to get the resolution of disapproval passed?
So here's how I would answer that. I think the reason why it's easier than most things or would be simpler than the sorts of exercises you're watching play out in real time on a daily basis in the House floor. If we turn on C-SPAN right now, they're probably falling all over themselves. But if you think back to, let's say, the efforts around the Affordable Care Act in 2017, again, with the Trump administration coming in with these majorities, the problem there wasn't the repeal part. They got repeal part down. It was the replace, right? And so the beauty of the CRA is it's really easy to unify Republicans around what they don't like. It's much harder to come up with a consensus of what they like. And going back to the substantially similar stuff, that is a unifying factor. Biden bad, vote for this. That is something they can get on board with. And so I think that's what makes it much more simple. But it does go to that question more broadly of, okay, where are the spaces? I mean, there's so much regulatory action in this administration. We'll see what slips into the look back period. But I do think it does inform where it might be ripest for the administration or for Republicans and an incoming majority to focus. I think all things will be difficult to marshal consensus on these things, especially with what will be relatively small margins. But it's significantly easier than anything else you could imagine them doing through legislative means. And the other thing is, part of the problem that Speaker Johnson is dealing with on a daily basis, and it's literally coming up this week, it's coming up next week, the idea of having to pass a rule, the procedural predecessor for actually putting something on the floor, because this is a privileged resolution, they don't need to do that. So there's a layer of procedure that goes away and makes everything a lot easier because you can just kind of put it on the floor in a way that you can't do with legislation.
Yeah, Liam, completely agree on that front. And I think also it will be critical to see what kinds of rules we're talking about as well. I think we have seen pretty unified Republican caucus when it comes to a lot of these environmental regulations, and that's an area where they tend to coalesce around, and what they sort of view as the overreach of the administration, and whether it's taking away consumer choice with regards to what types of vehicles people drive, or it's the type of analyses that the agency was involved in doing and promulgating the rule. So I think we will see pretty well unified activity there. Maybe on some of these other regulations that we've been talking about related to potentially some of these tax credits, those might be more difficult to peel off, and there may be certain benefits that would accrue to someone's district or state that would make it difficult for them to sort of peel those back. And then again, I think we ought to play the Donald Trump card here a little bit, and that if he is supportive of signing some of these disapproval activities into law, the Republicans do not seem to buck his direction, and that's powerful. And so I think that will be another factor here.
Yeah, I don't think I'd have to check this, but I don't think they failed a single one of the CRA. There were ones that were initiated that didn't get across the finish line. But I mean, as we said, I think there were 16 in 2017. So it was sort of target practice at that point. So I do think, to Joe's point, to the extent that it doesn't unify itself just by virtue of being a Biden rule and Republicans live in opposition to that, I do think Trump cracking the whip is certainly what could get him over the finish line.
This has been, I'm sure, really helpful for our listeners. I know it's really helpful for me and Daniel to get some of this information and insight from you guys. And we, of course, have clients that have particular concerns about regulations and how they're going to pan out and what their finalization looks like, whether maybe they would be in the look back period. Is that something that you guys get asked about a lot? Can you take a look at particular regulations and kind of assess in the future how they're going to pan out depending on political results in November?
Yeah, well, thanks for that, Taylor. I think this is a really unique area where you have sort of the confluence of regulations, law, politics, and they all come into play here with regards to the Congressional Review Act. So we are regularly advising clients on issues related to the CRA and trying to sort of crystal ball out what could happen under different sort of political scenarios, but also I think looking at things as well as to sort of, well, what is the agency thinking on the regulatory side? How quickly are they going to get these rules out? Which ones are going to be prioritized above others? And I think we're all sort of constantly looking at the OMB webpage to kind of see what the status of a particular rule is and whether or not it will take the full 90-day review over at OIRA, and then what does that mean? And certainly we've also seen that too as agencies make decisions to either, as I said, sort of split apart rules or either remove sections of major rulemakings and to try to get these rules completed in a timely fashion. So always really interesting questions on this, and really interesting interesting sort of thought exercise that I think really plays into our wheelhouse here with the sort of the confluence of issues.
Yeah, I think to Joe's point, we had a great discussion here, but it raises many questions as it answers, because there are a lot of complex sort of secondary questions that stem from this, not least some issues where we don't have a lot of precedent, especially we sort of glossed over that question of what happens with the IRA tax title, but we've never seen the CRA used on tax regulations. Could it happen? Sure. But you have to think about all the political dynamics, the policy dynamics, the regulatory dynamics, everything coming to bear. And I think to Joe's point, at the Policy Resolution Group, we try to do all those things. And that's really great working with our environmental group and throughout the firm to help clients on these issues.
Well, Joe, Liam, it's always a treat to have you here at the Environmental Law Monitor. Thanks so much. And for our listeners, if you've got questions about the CRA and what's happening this November and implications for not just environmental policy, but any kind of policy, I think you know who to reach out to now. So do that. And if you're new to the podcast, do subscribe. We don't want you to miss any of the great content we've got coming out around all of these rules, around Supreme Court cases, and what's going to be going on in 2024. It's going to be a big year. So thanks for tuning in, and we'll talk to you soon.